Hello, everybody. Welcome and thank you for joining us for this Ciarb webinar, 2025 in Focus, Charting the Course for 2026. My name is Aruna De Silva. I'm a Senior Dispute Resolution Advisor here at Ciarb in London. This webinar is part of a two-part series where we explore major developments in ADR and look at what happened over the past year, as well as look ahead at what lies ahead for 2026. We will discuss how global economic and political shifts in key regions have impacted the ADR landscape and explore the emerging trends and innovations shaping 2026. The focus of today's webinar in this first part will be for Africa, the Middle East, and on the APAC region. Before we get started, I'd like to address a few housekeeping points. The webinar is being recorded and the recording will be shared with the participants after this session. We encourage interaction during this webinar. If you have any questions for the panel, please leave it in the Q&A box, which you'll find at the bottom of your screen, as well as the chat box, which you can use to pose questions to our speakers. You can also sort of engage in the general discussion as and when speakers sort of come up with issues that are of interest. So feel free to use the chat box from the very start of the webinar. We have an excellent lineup of speakers joining us today for this webinar. And so let me, without further ado, start off by asking them to introduce themselves. Looking at my screen, could we start with Gitu, please?
Thank you. My name is Githu Muigai. I practice in Nairobi, Kenya. I'm a professor of public law at the University of Nairobi, and I am a fellow of the Chartered Institute of Arbitrators. I'm a chartered arbitrator, and I have handled many disputes, domestic, regional, and international. And I'm very happy to be here at this forum.
Thank you very much, Gitu. Arta, can you go next, please?
Sure. A very good afternoon to everyone on the call. Thank you for taking the time and joining us. My name is Arta Al-Karimi. I'm a chartered arbitrator and accredited mediator. I'm based in the UAE. I predominantly sit as arbitrator and I have served in many different jurisdictions as arbitrator. I was nominated on behalf of my committee here, the Ciarb UAE committee, to be with you today and speak with you.
Thank you, Arta. Thanks for that. And last but not least, Donovan.
Hi, everyone. I'm Don Ferguson. I am a partner at a law firm in Hong Kong. I've been in Asia for about 20 years, working in disputes, predominantly arbitration related. I am the immediate past chairman of the East Asia branch of Ciarb in this region, which is why I was nominated to come and speak to you all today. So thanks for coming. Let's make this an interactive and informal discussion where we can talk about key things that have developed in our regions over the past 12 months.
Thanks, Donovan. Thank you for that. So getting right into it, this webinar is sort of structured into two parts. The first part will be for speakers to provide an update and overview on ADR developments from each region, and that will hopefully help frame today's discussion. So to kick things off, can I invite Arta to speak about the Middle East?
Sure. I have 10 minutes to speak about three items with you here. One is a brief overview of our branch, who we are, what we do. Then an overview of the jurisdictions we have in the Middle East in terms of common law, civil law, what it is. Not all of you may be familiar with it. Then I want to talk a little bit about developments in institutional arbitration, court decisions, and alike. So we have a very active CIR committee here in the UAE with a Dubai branch and Abu Dhabi branch. The Dubai branch is led by our co-chairs, Rashma Ogura and Casa Halliday. Abu Dhabi is led by Maria Zawi, who's also the registrar of Arbitrate AD. We are very proud to say our vice chairman of the CIRB is also based in our region, who is Mike Tonkin. We are one of the largest branches of Ciarb with many members who are not just lawyers and arbitrators, but a lot of expert witness and engineers as well. So very proud to be an officer of the committee of the Ciarb in my region. Now, for those of you who are familiar with the UAE, you know that we are not just a civil law jurisdiction. We have common law seats here as well, which are the ADGM and the IFC, these two courts, and then the mainland Abu Dhabi and Dubai courts as well. This structure of a blend of, pockets of common law and civil law is not unique to us. We see it elsewhere in the Middle East. If I'm correct, Qatar has it as well. If I want to talk about development in institutional arbitration legislation or court decisions here, I must say that there are plenty in our region, and there were plenty in 2025. The region is moving towards being more and more arbitration friendly, which is great news. Great decisions are coming out of Abu Dhabi mainland courts, Dubai courts, and of course, our common law seats. I can give you a few examples, if I may. One that may sound insignificant, but it's actually very significant for those of you who sit on, let's say, construction arbitrations, and you have to sign awards that are sometimes hundreds of pages. A decision came out effective 4th of August 2025. This was decision number 1 of 2025. And that was issued by the Unified Federal Procedure of Arbitration Awards, if I may say. Local Judicial Principles Unification Authority, it's called decision number 1 of 2025, that basically clarified that only the last page of an award should be, not that it should be signed, could be signed, and it would be sufficient, rather than signing every single page of an award. That's a relief, because for those of you who sign large awards, you know that it can take a lot of time. It can actually take 4 or 5 hours. If you sit there and you have, let's say, 6 copies among 3 arbitrators to sign all these pages, it can really be not time efficient. So that was clarified. We had another award that came out in July of 2025. The Dubai Court of Cassation affirmed that arbitrators in the UAE-seated arbitrations have the authority to issue anti-suit injunctions, basically. This ruling protects... sound is very low, okay? I'll speak a little loudly, sorry. In July of 2025 decision, the Dubai Court of Cassation affirmed that arbitrators in the UAE-seated arbitrations have the authority to issue anti-suit injunctions. And this ruling protects the arbitral process from parallel court proceedings. This was very important. Another development was that the Dubai Court of Cassation reversed a previous approach ruling, saying that an arbitration clause remained enforceable even if the case was basically terminated due to non-payment of an arbitral fees. Sometimes you see in various jurisdictions that maybe the respondents refuse to pay its share of the fees. And that there was a court ruling previously here that said once that happens, the party loses its right to arbitration and now they can go to court. So this provision was being misused. And now the Court of Cassation has clarified it, that arbitration clauses remain valid even if one party decides not to pay its share. Another decision was that the Dubai International Financial Center Court of Appeal ruled in March that foreign and domestic interim measures can be enforced as final awards under the DIFC arbitration law. What other developments I can speak about? There are some developments also in terms of use of AI and other things that I'll leave for the rest of the webinar. I'll get into those later for you. That's it. Thank you.
Thanks, Ata. Thanks very much for that roundup of the Middle East. Donovan, can we ask you to go next?
Yeah, sure. Everyone, what I was planning on doing now is just giving you some context of arbitration in APEC because it's a huge subject and a huge territory. And then, as Arta just said, let's deal with some of the more specific details, the more specific developments a little bit later on. So, Chartered Institute East Asia branch, we're very proud to say, and I think this is right, I think we're the largest branch of the Institute, and we've got about 3,000 members, including students throughout the region. Now, to try and give you some updates of APAC is so difficult and so big just because of the geographical spread that we cover. So East Asia branch, the branch that I just mentioned, we cover Hong Kong, Cambodia, mainland China, Indonesia, Japan, South Korea, Laos, Macau, Mongolia, Philippines, Taiwan, and Vietnam. And we've obviously got chapters in each of those, or in most of those places. And then in addition to East Asia branch, we've also got branches in Singapore, Thailand, Malaysia, Sri Lanka, and of course, Australia. So we've got about 20 different countries that we cover in this region, which makes it a really interesting place to work and also to live. But what I was going to do today is really focus on Hong Kong and mainland China, and then also throw in some statistics about Singapore as well. I'm not sure how much everyone knows about Hong Kong and the way that things work here. So I was just going to give you a couple of points to bear in mind as we go through these developments. So Hong Kong is a special administrative region. We're part of mainland China. We're part of China, and we operate under the one country, two systems model. Now, you've heard a lot about this. I'm sure you've seen a lot in the press about this. And I just want to be quite clear what this means. So what this means is that Hong Kong maintains the common law. And when Hong Kong was passed back from the British to the Chinese in 1997, there was a promise that the common law would continue for at least 50 years until 2047. So what we see in Hong Kong is that we've got the basic law, which is our mini constitution, that is then supplemented by comprehensive statutes, and then also the cases that come from common law, both in Hong Kong, but also in other jurisdictions. In the arbitration space, one misconception or one point that I just want to clear up really early is that we're lucky to have a robust and fully independent judiciary. And I would challenge anyone to pick up the cases that come out of Hong Kong and Singapore and other jurisdictions in our part of the world, and try and find a more pro arbitration judge anywhere else. The last 5 years for Hong Kong and Asia has been really difficult, like the rest of the world. We've had challenges ranging from geopolitical tensions. We all know what's been happening between the United States and China. Thankfully, I think that's easing up a little bit, but it's been a challenge that we've all faced. We've had COVID, which I think impacted Asia very significantly. And we've had real supply chain issues and disruptions throughout APAC. So we've had a really interesting but also challenging last 4 or 5 years. But what we can say is that I feel this region is really optimistic and getting back on its feet. The last 2 years have in particular been really busy and exciting for us. You've all read the Queen Mary University of London survey, which they produce each year in conjunction with White and Case. And I was really pleased to see that Hong Kong and Singapore equally ranked number 2 in the world as the preferred seat for arbitration. So that's fantastic to have 2 of the top 3 in APAC. I think is really exciting. Also interesting though, and I think a lot of people maybe didn't realize this, is that in terms of the top 6, we have another 2 on the list. We have Beijing, which everyone knows and has heard of, but we also have Shenzhen, which is part of the Greater Bay region. So 4 of the 6 top arbitration venues in 2025 rankings came out of this region, which is great. Statistics everyone looks at them and thinks it's really interesting, but I'm really pleased to report that Hong Kong and Singapore have had record-breaking years last year. HKIC haven't released their 25 statistics yet, but in terms of their 24 statistics, they had 350 new cases, a 25% increase on the year before. And in terms of their value, it was a record $13.6 billion in disputes. And Singapore was even more impressive in terms of cases. Their new cases had 625 new cases in 2024, with the total sum in dispute of about $11.8 billion. So these are fantastic statistics and shows that this area of the world is really busy. I wanted to give you a feel for the sectors and the areas that are actually keeping everyone busy in this region, because I think that's an indication of what we're going to see in 2026 in terms of workflow. The first one I wanted to mention was capital markets. It's quite amazing to see the number of IPOs and corporate deals currently happening in this area of the world. In 2025, Hong Kong retained the top global seat of IPO spots in the world, and this was the first time since 2019. We've got more than 300 active IPOs in the pipeline, which is 267% higher than last year, and almost 300 billion Hong Kong dollars was raised in the capital market space. When I speak to my corporate colleagues, they're all ridiculously busy. We've already seen disputes arise out of these corporate transactions, and I bet my bottom dollar that we'll see disputes over the next 2 or 3 years come out of these, given that we've got the most significant M&A activity in this region than we've seen in the last decade. The other area that I just wanted to touch on by way of introduction, particularly with our other speakers to see, and a lot of our attendees, is the work that's arising out of the Belt and Road Initiative. Now, a lot's been said about this over the last 5 and 10 years, and I know people have different views on whether or not there has been as much work as people had expected. But a report was released in January called the China Belt and Road Initiative Investment Report 2025 that was published. Anyone that's interested in this this report, I recommend it to you. A guy, Christoph, out of the Griffith University. A couple of points just to touch on. 2025 saw the highest BRI investment ever for any year, with $128 billion in construction and $85 billion in investments, 62% up from last year for construction and 82% up in investments. Africa topped the rank of BRI engagement, 61 billion, a plus of 283%, followed by Nigeria, Saudi, and Iraq. The focus has been energy, mining, and new technologies, which is what we're seeing similar in our IPO capital market space. And interestingly, since its establishment in 2013, a cumulative BRI investment reached US $1.4 trillion, which is quite staggering. And we're now seeing the effects of those investments flowing on to the disputes. So, Aruna, I might just stop there. That's what's keeping us busy. That's a state of play generally in the region. And of course, happy to take questions later on.
Thanks, Don. Certainly seems that there's an upward growth trajectory in APAC, despite challenges in the past few years. We do have a couple of questions in the chat box, but before we get to those, I think we will now move on to the Africa region and an update on that from Gitu.
Thank you, Aruna. I welcome the opportunity to speak about what's going on the African continent. If you ask me to summarize 2025, I would say it was the year of the great recalibration, because we spent decades talking about Africa's potential in ADR. And in 2025, we tipped over from potential to actuality. And a lot has been happening in this continent. I'm happy to share. For example, in January the 2nd, 2025, ICSID registered a request for arbitration from Gavix Uranium against the Republic of Niger. And this dispute, some of you may know, concerned the revocation of a mining permit for the Maduela project. The basis of the revocation was the 2007 Mining Convention and local investment laws. What is the significance of this case? This case demonstrates, it typifies a perfect storm between resource nationalism, green energy demand, and sovereignty. This case is emblematic of the African landscape in 2025. On this continent, we are sitting on $248 trillion in mineral wealth, $500 billion in infrastructure that is in the pipeline. The disputes arising out of this are real. They are high value, high stakes, and very politically charged. So I'd like to talk to you about 2025 under four themes very quickly. First, the theme of institutional harmonization. In 2025, we had the Ohanda Transformation. This is the Organization on the Harmonization of Business Law in Africa. And something very critical happened. In June, the Common Court of Justice and Arbitration released its new rules of procedure. For those accustomed to operating primarily in Anglophone markets, this development was huge. First, the new rules streamlined the initiations of proceedings and appointment of arbitrators. The real impact was on enforcement. And that is, an award rendered under these rules now becomes enforceable in 17 Ohanda member states. Now, for practitioners in our area, that is huge. You do not have to reapply to enforce an award in another court of a member state. This is like a legal Schengen zone. You get an award in one area and you enforce it without. We in East Africa look very enviously at this, and we are hoping that we will be able to replicate something like this. There was an important milestone in December of 2025. The International Chamber of Commerce reached a historic milestone. It registered its 30,000th case. Why does it matter? Because this 30,000th case was a case by African parties, meaning Africa is beginning not to be the subject of international arbitration in London or Paris or in some other place. Africa is becoming an active user of arbitration platforms voluntarily among ourselves, and that's very, very major. This growth in African participation is replicated in many other areas. In 2024, African parties were the second largest user group at the LCIA, surpassing UK parties. In 2025, disputes involving sub-Saharan Africa states accounted for 24% of ICSID cases, the largest single regional share. This visibility signals not just volume, but also confidence. African parties are choosing arbitration, and that is very important. Another thing that is happening on the continent that is very exciting is that arbitration institutions are beginning to specialize. For example, the Lagos Court of Arbitration, the LCA, in November 2025, continued to lead in energy disputes. In fact, in November, it introduced the Modified Carrier Agreement framework so that international oil companies can divest from onshore assets and indigenous firms can take over, and the financing structures are complex. This innovation obviously makes Nigeria and Lagos in particular a preferred choice for regional disputes involving that sort of framework. In Angola, in June of 2025, the Angolan Bar Association voted to establish a working group on the establishment of an OAA arbitration center. Now, many of you know Angola is a giant in African oil, and this shift towards arbitrating energy disputes is very, very useful. Finally, there have been some very, very critical legislative initiatives in South Africa, one of the most important economies on our continent. South Africa has finally ratified the UNICITRO model, becoming the 11th African country to do so. That is massive, that is very important because it will help secure our region as a viable center for UNICITRO type arbitration. In Kenya, that's my home country, we have shifted substantially. We have drafted a stand-alone dispute resolution bill, which encompasses a dispute resolution policy. Now we have an arbitration amendment bill with emergency arbitrations and third-party funding. This has been a big issue here for many years. Finally, we have some consensus around it. We have a construction adjudication bill. This is critical for many of you know that in this sector, there is a cash flow cancer that is generated by the failure to have expeditious dispute resolution processes. We are addressing that by having the construction adjudication bill. Eventually, my last comment is about judicial attitudes. We have fought for many, many years to have the courts support arbitration in meaningful ways that help the arbitration sector to grow. In Kenya, we have seen a very robust support process by the judiciary, and we have seen the same in South Africa, we have seen the same in Mauritius, and we have seen the same in Nigeria. And at the heart of all this is the recognition and that the judiciary should have very minimum interventions in the arbitral process so that arbitration may proceed expeditiously. And so that change in judicial attitude in our part of the world has been very useful. I'll stop there and I can come back when any questions are raised.
Thanks so much, Gitu. A lot to unpack there, and I'm sure we can do deep dives into some of those topics in the second part of the webinar. Just to sort of address a couple of questions that have come up. Arch, I think there's a question for you on electronic signatures and how they're used in practice in the jurisdictions you're familiar with. Would you like to take that one? You're on mute.
Apologies about that. Yes. Electronic signatures have been supported by the laws of the seat of the UAE in all jurisdictions we have here, DIFC, ADGM, mainland, Dubai, Abu Dhabi. Now, the question is, how does it work? Routinely, I've seen that tribunals sign electronically. However, electronic signature, we should stick to the definition that it's provided under the law and the rules. It is basically provided by a service provider that uses encryption, and it can be traced back to who has signed it. It's not just a copy paste of your signature through, let's say, Adobe Acrobat into the document that you lift and drop. That is not the electronic signature we are talking about. It's a certified way of signing something. And it has been used. It's very, very helpful, especially when you have tribunal members that sit in various other jurisdictions. But that said, in practice, I have also seen that parties request ink signature. And when they do that, when together they request that this is what they want, I have not seen tribunals insisting that we are going to implement the law and too bad, we are going to sign electronically. Usually tribunals accommodate the parties and provide a wet signature on their documents. But to answer your question, yes, it is very much acceptable to use electronic signature. It's just that we need to make sure it's the type of service like DocuSign or eSign or these service providers that provide encryption. And there's a banner that appears on top of your document saying it was electronically signed, and a separate page gets usually attached to the bottom of the award showing who signed at what time, and information about IP information also about, how you signed it is included. So yes, that's electronic signature.
Thanks, Atta. Thanks for that. There's also a question about a reference to the case you mentioned. I'm sure we can drop that in the chat box during the course of the webinar.
Yeah, I looked it up. If you want, I can pull it up. I took a screenshot. One thing to generally mention about court orders in the IFC and ADGM, these are all available. They're publicly available court orders. You can basically go on the IFC's website and pull all of these up. It is a number, if I'm not mistaken, I've seen a small excerpt of it on LexisNexis, and that is case number 34 of 2025. You may wish to check that.
Thank you. That's very helpful. Shifting gears a bit, we'd like to move on to the second segment of the webinar. And part two will be a Q&A style roundtable discussion on several cross-cutting topics and trends from 2025 and sort of looking into 2026 on how these trends will develop. We have structured the second part of the webinar on several topics, including on institutional arbitration and innovations, as well as AI technology and few other topics as well. So the aim of this part of the webinar is to be as interactive as possible. So we encourage our audience today to keep the questions coming, and our speakers are more than welcome to address these as they come up in the Q&A or in the chat box. So moving to the first topic, we would like to sort of address innovations and developments in terms of the rules promulgated by arbitral institutions. It's a question generally for all the speakers, and I'm happy for all the speakers to sort of address the key developments in their respective regions on this. The question is, what are the noteworthy innovations that institutions have developed and implemented in 2025? And how do you see those developments impacting practical outcomes in cases? If we're going by an order, could I ask Donovan to take that question first, please?
Sure, Aruna. I'm going to deal with two things. I think it's topical to the region. The first one is the arrangement that's in place in this area between Hong Kong and China in relation to interim measures, because it's something that has been around only for a couple of years, but we've done the most number of these applications last year than we've ever done before. So just very briefly, what this is an agreement between Hong Kong and mainland China, whereby if you've got a Hong Kong seated arbitration that's administered by one of the designated institutions, you can actually go to that institution and ask them to go to a mainland court to get interim measures. And the most common one is obviously the freezing of assets. Now, this is really interesting because it's the enforcement of interlocutory decisions from a Hong Kong arbitration in the mainland. But more importantly, the test for freezing a party's assets is really quite low. So if you tried to do this in a Hong Kong court or many other common law jurisdictions, you'd need to show that there was a real risk of dissipation of assets. You'd have to see that the respondent is trying to, sell assets, move property to effectively undo the benefits of an arbitration award. That's what you'd need to normally show. But the test is not that under this procedure. The test is actually really quite low. And what we're seeing is record number of these applications being successful. So I think since this arrangement came in force in October 2019, HKIAC alone, the Hong Kong International Arbitration Centre, has handled 175 applications, and there's been more than $4 billion of assets frozen. So one of the big trends here is that if you're in a dispute with a Chinese party, a mainland Chinese party, or a party whose assets are located in mainland China, if you've got a Hong Kong seated administered arbitration, the trend is for these applications to be made to effectively freeze their assets. The other big thing that we've seen recently, and it does surprise me a little, is the use of emergency arbitrators. There's been a huge uptick in these applications over the last 12 months. I've personally done 5 of these in the last year, where I've probably only done 5 in my entire career in my 20 years before that. So it's a real shift. And I've been asking myself why, because traditionally parties would rush to the court in order to seek interim relief because there was no doubt about the binding nature of a court order, and there was a view that they would be more readily complied with by the parties. But absolutely, that's not what we're seeing here. And Singapore updated their rules very recently to introduce an interesting concept where you can actually go and seek a protective preliminary order from SIAC and the appointment of an emergency arbitrator on an ex parte basis. So what that means is you don't need to tell the other party that that you're going off and trying to seek this relief. Now, it's a very compressed timetable. It happens in very limited circumstances, but I think that's a really interesting development that the Singapore Institute have brought in their new rules, because to be honest, I wouldn't be advising many parties to go ex parte in front of a Hong Kong or a Singapore court. So that's a really interesting development. The other thing I just wanted to briefly mention is in this region, there's lots of discussion about whether arbitration has lost its way, whether it's too slow, whether it's too expensive, and whether the practitioners who are running these cases are running them more like court litigation as opposed to ADR, which is what ultimately this was all designed to do, to resolve commercial disputes quickly and efficiently and better than the courts. And I think in the last 12 months, we've seen a real shift from the institutions and also the arbitrators to get back to basics. And for example, we've seen the HKIAC amend their rules so that expedited procedures, single arbitrator, documents only, 6 months awards can be mandated now for disputes under $50 million. So that's about 7 or 8 million USD. So not insignificant, and double than what the rules used to previously provide. So I would say, for me, the big change, not only in relation to instrument measures, but also the appointment of emergency arbitrators, is a real desire or mandate from institutions in this region to conduct their arbitrators quicker and more cost effectively. I'll stop now, Aruna, and let other people jump in.
Thanks, Donovan. Thanks for that. And sort of the speakers are welcome to sort of chime in on whatever Donovan mentioned about emergency arbitrators. I think it'll be interesting for our audience to hear whether there are similar innovations happening across your regions as well, and whether emergency arbitration is as popular as it sounds. It sounds like it is in Asia. So moving on to the Middle East then. Arta, do you have any updates on institutional innovations for us?
I do, but before I give you the updates on institutional and innovations, I want to let the audience know that I really missed one of the major developments that we had in the region, and that is actually in the United Arab Emirates, I must say, our entire civil transactions code that was promulgated in 1985 is being revamped and replaced by a new law. So we had the decree signed on 30th of December 2025, and this law is going to take effect and be fully enforceable in I think June of 2026, because there's a 6 months period when the law is actually fully enforceable. And that is significant for the region because it's going to make the region a lot more business friendly. The decision to make this is to bring clarification to certain sections of the law that parties found ambiguous. For example, good faith provisions. And I'm not giving legal advice here because I'm an arbitrator. I'm a full-time independent arbitrator. You may want to look this up. A lot of law firms have written on it, but perhaps this is the single biggest, I think, development that's coming out of the UAE. I want to go back to Donovan and what he said with respect to freezing of assets that you see in his jurisdiction in Hong Kong and China, especially with respect to Chinese assets. We continue with the same pace in the UAE, and where you see interim measures being sought from the court, and I think it is wise to seek it from the court rather than arbitral tribunals because they have still a little bit more teeth, is when it comes to freezing bonds. And that happens very regularly on construction projects. That's the area which I am predominantly engaged in. In my previous life, I used to be a construction lawyer. So as soon as there is any feeling of uncomfortableness or thinking that maybe a bond is going to be pulled, even before start of arbitration, parties basically go to court to seek an injunction and freeze that bond. A lot of the times what you see on construction projects in our region that contractors have provided on-demand bonds. And on demand, basically, what it means is that at any time, the owner or the developer feels there is a need to, they can potentially liquidate this bond without notice. Of course, that in practice doesn't happen. Usually there is some notice provided by the developers or the owners. And even at times we see the banks inform their clients, contractors that, listen, we are going to allow your bond to be pulled. Just they say that. And of course, if a bond is in demand, the banks have to comply with it. They are not going to resist it. They just have to do it. So we see that going forward a lot. It is not with respect to any nationality or any group of people in the UAE. This is just the law. It's the practice applying equally across, depending on what the parties have signed in their contract. So we do see that, especially in the construction business, quite a bit. And it takes something around immediate freeze, like it takes about a week or less. Parties will go to court and argue this, but oftentimes bonds remain frozen till arbitral proceedings are finalized. We see that a lot in our projects. I don't think the same type of relief, if it's sought by the tribunal, from the tribunal, it may not guarantee that it is effective. If a tribunal issues, let's say, an interim award or a procedural order, it may not, it usually doesn't have the same implications as a court order would. So it's not such a bad idea when people go to court. Belt and road initiatives in the UAE, I don't see that. I haven't seen a specific flagging of these disputes. We do have Chinese parties doing business in the UAE. If a dispute arises, I would imagine if arbitration clauses are in there, they would go to one of our centers. Depends on what the rules are, what the institution is, what the contract says. So it has been hard for me to be able to frame that this dispute is actually a Belt and Road Initiative dispute, the way you may have it in Asia. As for the institutions and what we see here, innovation has been a big thing for all of our institutions here in the Middle East, in the UAE, if I may say, give you an example. We have 4 major institutions or I would say maybe 3 in the UAE. It's Dubai Arbitration Center, which is 35 years old, has probably the biggest and busiest caseload. They signed 2 agreements recently. One was with Opus 2 to bring in a platform that's called Dana or Dana. And this platform streamlines case management for DIAC and also provides, I think it helps with arbitration, note taking, and what in the US we called court reporters, here, transcribers, with transcription and all of that. That is being launched. The other thing is they signed an agreement with Yusmundi in order to use their AI product. And that can provide a lot of efficiency around arbitration for DIAC and its case managers. Arbitrate AD, same. They have a fantastic platform that, it's a central platform. As you know, Arbitrate AD is a new institution. It was established in 2024. And this is to eventually fully replace ADCAC that we had in Abu Dhabi. And any new cases that are now being filed, new arbitrations that had the ADCAC provision for institutions go to Arbitrate AD. And they have a fantastic document management system as well. We also know that ICC Team 12 sits in the UAE. They work out of Abu Dhabi, fantastic team. And ICC also has Opus 2 that have recently streamlined everything. They had it previously, but it's been updated as well. That's in terms of technology. And another thing I wanted to tell you is our region is on sort of an alert, if I may say, when it comes to use of AI, because recently the court in Doha and also Abu Dhabi ADGM courts picked up on situations where counsel had used AI to produce pleadings without checking the references to where these case law came from. In the case of Doha, counsel got away with a major notice, no sanctions and fines, and they were told that they really need to basically be careful next time because their names are going to go public if they do that. What happened is counsel had put in some references to cases without checking these references. The adversary came and said, listen, I need these cases. I can't find them anywhere. Court got involved, and the lawyer had to apologize and say, well, yes, I've used AI. I really don't know what these are. And just imagine how embarrassing that is for a lawyer. In the instance of ADGM, and I have to go on their website and check, this was a more recent case, and I believe the counsel was sanctioned, but that is to be checked. I don't want to misspeak on the call. So we are all very much aware of this now, and as an arbitrator myself, I am also very aware. I check every reference, whether I am using AI to summarize something or whether party is giving me a pleading. These need to be checked. So that's for that, basically. And I will stop here so we can actually have more time for Q&A.
Thank you, Ada. Thanks a lot. I'm sure other speakers would also have a lot to say about the use of AI and development of guidelines and practice directions, etc. Before we head into that topic, let me now turn to Gitu to speak about institutions and institutional innovations in Africa.
Well, as I mentioned earlier, one of the most exciting things that has happened here is the change in law in a number of countries. I have already talked about South Africa and the adoption of the UNICITRO model law. And I'd like to talk about very exciting things that have happened in Kenya. And one is the recognition of emergency arbitration, something that has been missing from our toolkit, and that now is in. Equally exciting is third-party funding. As you may appreciate, there are many deserving cases that arise where parties cannot finance the arbitration process because it is prohibitive. Now we've been able to have in place a framework that is well regulated, allowing reputable funders to support meritorious claims while safeguarding transparency and procedural integrity. I've already talked about unlocking cash flow in the construction industry by having a standalone construction adjudication law. So these are very important things that are happening in terms of law reform. One thing that that holds great potential, very great potential, is arbitration in the Africa Free Trade area. And to my mind, this is going to be a real game changer because it will bring together a very, very large number of African countries within that free trade area. And the dispute resolution mechanism will be within the free trade area. And therefore, the argument as to whether to litigate or arbitrate has already been won. For many years, we kept advocating, but now that is won, and I am very happy about it. I worry still about the proliferation of arbitration centers. There is arbitration nationalism that is a bit negative. We have an arbitration center in Rwanda, very strong. We have an arbitration center in Kenya, very strong. We have one in Mauritius, very strong. South Africa has its own, very strong. I do not think myself that that's the direction we need to go. I think we need to have strong regional arbitration centers. I would be, if I had my way, we would have the arbitration center in North Africa. That probably would be in Cairo. We would have one in West Africa, that would be the Lagos one. We would have one in East Africa, that would be the Nairobi one, and we would have one in South Africa. And in my view, that would be ideal. But this proliferation is not giving us the benefits of strengthening the institutions, strengthening capacity, and engendering independence in that regard. I could say many other things about what is going on, but I feel that the acceptance of ADR is probably the biggest victory that we have had. Number two, the acceptance that African disputes can be settled in Africa, obviously with the help of other actors, including arbitrators coming from all over the world, is a major achievement. The sensitization of the judiciary to the fact that the arbitration process is a partnership with the judiciary. It's not a competition with the judiciary. We've won that argument, and I think that, so in my view, we are primed for takeoff. I'll stop there and allow any questions.
Thank you, Gitu. So moving on to the next topic we want to discuss during the webinar, we focused very much on arbitration innovations and thought it might be good to sort of see what's happening in the regions in terms of mediation, adjudication, and any other forms of ADR. The speakers have highlighted developments in these areas at the start, and we'd like to do a deep dive into the regions and what's really going on in mediation and adjudication. We'll stick with you, Gitu, to kick us off on this. If you can tell us and walk us through the developments in Africa with regard to adjudication as well as mediation.
it says unmute. You do see significant institutional changes across the continent. I have referenced changes in Nigeria, for example. I've referenced changes in South Africa, in Zambia, in Malawi, in Kenya, in Rwanda, in Egypt, and so on. So in my opinion, ADR as a mechanism of dispute settlement is receiving continental-wide acceptance. And I expect this to continue. There are a number of, as I have mentioned, the UNICITRO model has only about 11 African countries that are signed on to it. I believe that this is beginning to change, and that we shall be seeing more and more African countries sign on to this. I am very excited by what is going on in the Ohanda area, the Organization for Harmonization of Business Law in Africa, as I mentioned earlier. This is an area where the harmonization of the dispute resolution mechanisms has taken off, and ADR is at the heart of that. As I said earlier, the legal Schengen zone that has been created is very exciting. If the same were replicated in East Africa and North Africa, it would be unprecedented. So to my own mind, we are on the brink of a major revolution in ADR in Africa. And the energy, the wind behind the sails are unstoppable.
Thank you, Gitu. Thanks for that. Donovan, anything in APAC? I think we spoke about mediation as well, gaining popularity. Can you sort of expand on whether other ADR mechanisms are sort of doing as well as arbitration is in APAC and in Greater China?
Yeah, no problems. Can I also just go back to something that Gitu said before? Because I think I primarily practice as counsel, not tribunal. So I think one of the difficult things about arbitration is obviously the awards are confidential, so they aren't often spoken about. So I think it's important to talk about these interesting things about how they play out in practice on a no-names basis, on a confidential basis, just so that we get a feel for what's actually happening in the different jurisdictions. So two things I just wanted to briefly mention. Gitu spoke about third-party funding. So we were talking about this a lot in Asia 2 or 3 years ago when it was changed so that the Singapore government effectively permitted third-party funding in arbitration. And of course, Hong Kong was quick to follow as well. So we've had this third-party funding around for a couple of years now. I was involved in a couple of cases in the last year or two where tribunals had to consider whether third-party funding costs could actually be awarded as part of the arbitration costs. One was in Singapore under SIAC, one was in Hong Kong under the HKIAC. The first one was a tribunal of 3, and I would challenge anyone to find a higher profile panel than that one. And the second one was a single arbitrator, again, very well respected in Hong Kong. In both of those cases, the tribunals actually found that the funding costs were recoverable. And there were many, many, many times multiple of the legal costs involved. So in practice now, in both of these jurisdictions and some others in Asia, we now know that tribunals are prepared to award the costs as arbitration costs. Neither were appealed. So it was never tested before the courts, and we don't actually have any law on that in this jurisdiction. But I thought that was something interesting to share with the participants today. The other thing I thought I'd share would be a recent case arising from something that Arta talked about the call on bonds. I'm aware of another case here in this region where rather than going to the court, the moving party applied to the arbitrator to restrain a call on an on-demand bond. Now, my advice to the client would be if you ended up in court, Absent fraud, you'd lose. Interestingly, this arbitrator found that the test under the model law was different in relation to interim measures and the grant of injunction, and he wasn't prepared to follow the old, general law on on-demand bonds, and found that the discretion was broader under the arbitration ordinance and therefore did actually restrain the demand, even though fraud wasn't pleaded. So I just raised that for everyone to think about in terms of something that Arta raised, that it's an interesting thing, an interesting point where you might rush off to an arbitrator if you think their discretion might be a little bit broader than a court. Okay, sorry, Aruna, back to the things you asked me to speak about. So I spoke about arbitration copping a bit of negative criticism about being a bit slow and being a bit expensive. That's probably a criticism throughout the world. Of course, that brings into focus alternative methods of resolving disputes. The biggest development in Hong Kong last year, which I'm saving up for now, is like in Kenya, the introduction of statutory adjudication for the construction industry. We have been speaking about it for 20 years. We've had 3 big contractors go broke in the last little while, causing huge problems in the industry, but now that all changes. So we now have statutory monthly rights to adjudicate payments, and if you're not paid, you go off to an independent third party who will, on an interim basis, decide how much you're entitled to be paid. It's rough justice like other jurisdictions. It's quick, it's dirty, it's pretty horrendous for those people that get involved in it as lawyers or practitioners or adjudicators, but it's really good for the construction industry because people are going to get paid. All up, it's about a 3-month process, and it's absolutely going to revolutionize the arbitration space in this region, because if experience in other places is anything to go by, it means that there will not be as many arbitrations as there traditionally has been. So we see a lot of arbitration practitioners and arbitrators in particular now skilling up as adjudicators, and I'm really pleased to say that the Chartered Institute of Arbitrators, the East Asia branch, has worked with the HKIC to train and accredit their adjudicators. So that's been fantastic. So that's one ADR development here. The other is mediation. I've never seen a stronger push for mediation in my life. The Hong Kong government has written to all of the big private companies and suggested firmly that they include mediation in all of their contracts. And we've just launched the International Organization for Mediation, IOMED it's called, as the world's first independent intergovernmental body designated to resolving disputes through mediation. Now, this was set up in, the convention was signed on the 30th of May. 80 countries have signed the convention, many countries along the Belt and Road. The organization itself was constituted on the 30th of October, and what it's designed to do is to promote mediation, to conduct mediations between states. That's the first bucket. The second is between states and foreign nationals, and the third is in relation to private international parties. So the government wants to make Hong Kong the mediation hub of the world. Another plug for the Chartered Institute, one of our global presidents, former presidents, Teresa Cheng, who I believe was the president in 2008, has been appointed the Secretary General for IOMED. She's a former Secretary for Justice of Hong Kong, and her role over the next 4 years is to lead the IOMED and promote this, which is a really interesting and exciting development for not only Hong Kong, but also the region and the 80 convention countries who have signed up to it.
Thank you. Thanks for that, Donovan. I'm sure, Arta, you also have some reactions about the adjudication and developments around education in the Middle East, given how construction is a very popular form of very popular industry from which disputes emerge in the Middle East. And if you can sort of enlighten the audience on any developments in ADR other than arbitration that's been happening in the Middle East in 2025.
Sure, I can do that for sure. But it's very interesting. I want to go back to what Donovan said about injunctive relief with respect to bonds. and just clarify a point that I meant. I wasn't talking necessarily about the powers of the arbitrator to issue or to grant injunctive relief rather than the strategic approach to issuing these. Because, of course, we regularly see that arbitrators do have the power to issue injunctive relief. The question then becomes the party and what they do with it. Because parties, I mean, again, this is strategy for counsel, not what an arbitrator can or cannot do. In my jurisdiction, you have to be able to have enough respect for the tribunal members that when basically this interim award is issued, parties abide by it. What if they run and despite of that, then they very quickly liquidate the bond through their bank? This can, of course, the arbitral tribunal will have the, let's say, how do I call it, the capacity or the power to address that in the final award in whichever way it's pleaded and they see fit. However, the party may at that, these arbitrations go on for many years. Let's say a construction arbitration can go on for 4 or 5 or longer years. Meanwhile, the party whose the bond has been cashed can lose bankability, and this can affect their future projects. So the question becomes for the council to think, where has more teeth? Do I go to the court and actually get an injunction and freeze these assets, or do I ask my tribunal to do that? So that was one thing I wanted to add there. With respect to adjudication, we don't see that in the region yet. We do not have a statutory adjudication law out here in the UAE. I'm sure it will be very useful, and it's eventually going to catch up in our jurisdiction as well. With respect to mediation, I 100% agree with Donovan. We see that here in our jurisdiction as well. Mediation is moving mainstream here, and there hasn't been, I think, in the recent history, the mediation in its definition of institutional mediation. I'm not talking about the majlis style, which we all are familiar with and we have in the Middle East, and it's very respected. It's a form of mediation that we've had for centuries. I'm not talking about that. I'm talking about an institutional mediation with a neutral mediator that doesn't know the parties and shows up and tries to do this kind of mediation, evaluative or other methods. It is gaining momentum in the UAE. What is the reason behind it? We are becoming a jurisdiction that it's increasingly hosting forward-thinking industries like fintech, all sorts of new innovations in technical disputes, AI, disputes with respect to sustainability. These are the businesses that are moving to this region. So just imagine what mediation can do for these businesses. A couple of months ago, I moderated a panel for the British Embassy here in the UAE, and we invited speakers from all over the world on our panel, major speakers, international law firms, talking about mediations and the reasons behind why it is so important for our region. And we had a former general counsel of a defense contracting company speak to us, and he gave us a very relevant example of this defense basically contractor was using a technology, and this was in breach of the patent. So the question was, should we go to arbitration and waste for 3.5 years, waste our time and get a final award, or do we go to mediation and find a way to use this technology? See, that's something that arbitration cannot necessarily provide, but mediation can. Mediation is extremely business friendly, and our jurisdiction is very acutely aware of the stuff that mediation can do here. So basically, yes, mediation is gaining momentum. DIAC has mediation rules. ICC tells us to write it in our procedural order 1 that parties can go to mediation and use the ICC mediation rules. So it is something that's gaining very much momentum. With respect to dispute review boards or dispute adjudication boards, the FIDIC style, we have seen it in our region. It is not mainstream. It is not something you see every day. But yes, on larger projects, we do also see the use of DAPs, very much so. So I'd like to leave more room for questions from the audience, so I'll stop.
Thank you, Atta. And yes, as a reminder to the audience to please feel free to sort of drop in your questions in the chat box or the Q&A. We do have some time left over at the end for audience Q&A, so please make sure that you make best of this opportunity and make use of this chance to get the insights from the experts. Since you sort of rounded up with technology and disputes regarding technology, Atta, I'd like to stay with you for our next topic. You did mention a couple of cases from the UAE regarding the use of AI. Are there any other developments or any sort of practical insights you can provide our audience regarding AI or technology or what's happening in the UAE in that regard?
What I can say is the industries here and our institutions are moving towards the use of kind of like regulating the use of AI. And probably ICC is on the forefront of that. And if I can pull up my documents in the background that I have opened on my screen, I may be able to read something for you. Just bear with me a second. If you go on, basically look up ICC and what they are doing in terms of use of AI, you will see that a lot has been happening. Sorry, it looks like I've probably closed this document. Okay, apologies. Yes. They've also formed a task force, a global task force for the use of AI that looks into ethical use of AI, transparency in use of AI, and compliance with basically the guidelines they are developing around use of AI. This is going to be a project for the next few years, and it's something that we are closely watching. As a member, I'm one of the UAE basically delegates to the ICC's Global Commission on Arbitration. And each time we go to these meetings, once a year, it was in Toronto, now it's in Paris as well. It's a topic that's heavily on the radar of the ICC and it's being discussed. The other thing is me and a lot of arbitrators I've seen here, when we draft our procedural orders, request the parties to look into the Ciarb guidelines on use of AI, which was published not too long ago, and be very transparent with us as to what kind of an AI they're using, and also basically promise that the use is going to be ethical and everything is going to be checked. Of course, the use of AI is something that's out there. It's beneficial if it's used correctly. However, there has to be boundaries around it and we have to use it carefully. And I encourage everyone to use AI. If it's going to save your clients time and money, why not? We don't want to be sitting here discussing whether it should be used or not. It should be used. It should be used ethically without breach of confidentiality within, proper parameters. And something from another jurisdiction is when I sit on AAA ICDR arbitrations as an arbitrator, they have used the product, they have developed their own AI, which is called Clear Brief. And Clear Brief assists tribunal members greatly, provides summaries of cases. Of course, you have to check everything. Even they have disclaimers there, but it's a hallucination-free AI system. It doesn't surprise you with cases that are not there. So institutions are working very heavily in either developing their own AI or coming up with guidelines as to how to use AI. And as arbitrators, we are also very aware of that. We remind the parties on where they can find these guidelines and hopefully follow them. I'm looking at my list and I think I'll stop there to give a chance to the other speakers to opine on this.
Yes, thank you, Aaron. Thanks for that. And yes, AI is certainly a fast sort of developing area, and it'd be interesting to hear whether the Chartered Institute guidelines or indeed any other sort of form of guidelines have been used in practice in the other regions as well. Gitu, would you be able to sort of elaborate on any updates in Africa regarding technology or AI?
Well, there is a wide use of AI, especially in the legal sphere in general, including in arbitration. I use it myself, but usually limited to editing, because that's a much simpler way doing it. We had a very embarrassing incident last year. The Court of Appeal in Kenya, which is a very, very highly regarded court, is very, very competent, has very, very sound reasonings, wrote a judgment in which they cited a statute that does not exist. And this ignited a big debate about, the reliability of AI. I think our problem here is compounded by the fact that we have borrowed from the Americans the tradition of assigning law clerks to judges. So the law clerks are instrumental in developing the first briefs and so on and so forth. They are heavily overworked, and I think their default mode is to cut a corner here and a corner there. And AI has therefore been much used by them. So there is a greater awareness. I hear the same in the neighboring countries of the potential of AI to make our work much, much easier, and also the danger of it distorting. When I hear arbitrations in my chambers, we switch on the AI the minute the witnesses begin to testify. And it is very, very, very useful. I am able, at the end of a hearing session, to print, to share with all the parties the recordings. And to that extent, it's very, very useful. It's going to make the cost of arbitration much, much lower. But those dangers that we have mentioned exist. I'll stop there.
Thanks very much, Vito. Yeah, indeed, there'll be challenges as well as sort of massive opportunities with the use of AI, and it's sort of a good warning for us as practitioners to be careful when we use AI, and sort of delegate our work to AI tools. Donovan, I'll turn to you now for updates on tech and AI from the Asia Pacific region.
Thanks, Aruna. Look, similar comments from me. It's here, it's being used, it's around to stay. And if anyone thinks differently, then I think they're going to be a lot less busy in the next 5 years. So I think we all just need to proceed on that basis. Two things that I wanted just to raise from my practical perspective when we use it is the first is you need to skill up on the specific jurisdiction and work out if there's any rules or guidelines or best practices for that area, for that place where you're arbitrating. So some jurisdictions in my region actually come out and say, you must not use this for any evidence preparation. It cannot be used in witness statements or affidavits. And if it is, the witness must actually declare in that affidavit that no AI has been used. And if you breach that, then it's professional misconduct on the behalf of the solicitor. So that's in some jurisdictions. Others just say nothing at all. So skill up on the seat of the arbitration and see if there's any local laws or guidelines that apply. Look, I think it's great. From my perspective, though, I must say when I'm settling one of my junior lawyers' work, it's incredibly difficult to pick up and fact check everything. And that's, I think, the key risk. And if I miss it, if judges in Kenya miss it, if all these people that are using it, I just think the point to realize is how difficult it is to actually validate every reference in a 20-page advice or a 40-page submission. And I think if traditionally a junior lawyer had done it, it's quite unlikely that they're going to make up a case, or make up a statute. They might get the law wrong, but they won't create something that you can't check. So I think for all of us, it puts a real onus on us to make sure that we spend the time checking. And I do wonder whether the cost of a senior lawyer or a partner checking everything might actually outweigh some of the savings that you get from the junior lawyers not doing the work. I don't come to a view on that, but I just raised that as a possible question. One thing we did, so we're trialing our firm various different platforms and AI services. So what we did is we finished an arbitration about 6 months ago, and we uploaded all those arbitration documents, all the disclosure, all the pleadings onto this platform. And then we tested it for about a week in terms of summarizing the evidence, looking at inconsistencies between people's statements, actually looking at the contemporaneous documents to see whether they worked. And I must say, I was really surprised. I reckon it did a job of probably a first or second year lawyer, but it only got to 70 or 80%. And anyone that you speak to who knows about AI says you don't think years in advance as to the developments. You're thinking minutes, you're thinking days, you're thinking weeks, you're thinking months. So after actually testing it on a real life arbitration, just to validate and test the platforms, 70 or 80% is pretty incredible, and it's only going to get better.
Thanks, Norman. I think it really sounds like across all regions, AI is here to stay and here to stay in the context of ADR. And it seems like from certainly Geethu's anecdote about the Supreme Court, that we're all sort of seeing the same sorts of challenges that we need to sort of address. So I think we can now sort of pick up a couple of questions that's come in. I think we're able to club those together. It's generally to compare mediation and arbitration and sort of pose this as an open question to all the speakers to sort of weigh in with your own experiences on these two types of dispute resolution mechanisms. The first one is what is more business friendly? Is it mediation or arbitration, or rather, is mediation more business friendly, and how is that the case? Second one is what's better in terms of resolving construction project disputes. In your experience, does mediation work, or is it better than arbitration? And this is an open question to any of the speakers who are happy to weigh in. Please ask.
Sure. First of all, mediation. I mean, it's very difficult to agree to mediation afterwards when matters become contentious if it's not in your agreement. So if you're talking about a proper institutional mediation, it's better for this to be in your agreement. But that said, it can also be used as a delay tactic. If you may be stuck. If you have a mediation agreement, you have to go to mediation. And this is an open-ended mediation agreement, not properly drafted, doesn't have a defined time period. It can be abused. It is a matter of strategy for the council to understand where they want to go and how they want to handle it. You need to really know your counterparty. You really need to know the opposite party to see whether they are going to engage in mediation, whether there is an incentive to engage in mediation. If there is, you have a lot to accomplish through mediation because you are not confined to the boundaries of the contract where the dispute has arisen. In mediation, you can do many things. You can come in there and say, okay, I have a dispute with you on this area. It goes beyond the confines of this contract. But how if I give you a share in X, Y, and Z outside of this contract, or however we form a joint venture to do something else, or many amazing things can come out of mediation when a mediator sits with you and brainstorms and allows you as a party to come to the conclusion of what suits you best. So mediation is not what you want, is what you actually need. And that's how mediators brainstorm and bring people together to think. It's very powerful. Parties should come to the table with an open mind to solve a problem. However, it can also backfire. It has been used as delay tactics in many jurisdictions. Arbitration also, same as mediation, if people have signed up to the Singapore Convention, it can be enforced in other jurisdictions. So this is just, it's a very interesting topic, and I really appreciate the question. We can have a separate webinar on this and discuss it because it is gaining foot, mediation, in many regions, and it's a very powerful tool. I'll stop there so other speakers can contribute.
Thanks,
In
Asha.
my experience, yes, sir. In my experience, mediation is very business friendly because if the parties agree to mediation in good faith, then it is very expeditiously resolved by parties who are negotiating in good faith. The mediator is able sometimes to bring his own knowledge, her own knowledge of business and of investments and finance to help the parties to get to yes. Now in Kenya, we have court-annexed mediation, where disputes are not allowed to proceed in court beyond a certain point if there is no evidence that an attempt at mediation has been made. Now, how successful has this been? Not very successful, because of the reasons some of my colleagues have given. There are people who see litigation as a way of prolonging the dispute and so on and so forth, and are not interested in an expeditious disposal. But in 50% of the cases where mediation works, the parties walk away from the mediation feeling able to do business together again. And that is important. I would encourage mediation myself, especially in areas where the parties cannot afford prolonged dispute resolution procedures because they need to get back to work, like in the construction area, and so on and so forth. Thank you.
Thanks, Gitu. Donovan, did you have any reactions to that, or?
No, look, I agree with what everything's been said. I think the key point is there's no hard and fast rule. You've got to think about it for this particular parties, the particular case, and then make a decision about whether you think it's going to be a genuine mediation where people actually want to try and resolve this, or whether they're wasting your time. I've unfortunately been in mediations with both, and you can normally tell pretty quickly whether you're in it for the right reasons or not.
Thank you. Do have a couple of questions. I think these are more region specific. So remind the speakers that we have around 3 minutes left, so we can pack in that time and answer these. The first one, I suspect, Arta, might be for you. It says the number of GCC free trade agreements is rising and all have trade negotiation and arbitration mechanisms. So considering differences between trade and commercial arbitration, do you think the GCC has enough trade arbitrators? If not, what is the best strategy for building expertise in this area?
That's a very interesting question, and thank you for asking it. Yes, GCC region is signing lots of trade agreements and bilateral treaties and all sorts of things, given the influx of huge amounts of investment here and technology investment especially, and we won't go through all the sectors that are arriving in our region. We are very lucky to see that. There are differences between investor-state or treaty arbitration compared to commercial arbitration, and the region is doing a lot of capacity building. Actually, DIAC a few months ago had a 3-day training that I myself went to see what's happening there and what they're talking about. I think we'll be in good hands. There are lots of arbitrators. We are doing the capacity building. Meanwhile, there are lots of arbitrators with experience in the region. They may not be sitting in our region. They can easily handle these cases while homegrown arbitrators catch up with what's going on. Very good question. And yes, we are fortunate to see that actually.
Thanks, Arta. Very quickly, final question, Gitu, might be for you. What's your view on the appetite for the uptake of construction adjudication as a way of resolving construction disputes in your region, especially in Africa, except for the likes of South Africa that have already adopted it? It can also be a general question to speakers. I mean, we've already mentioned about Hong Kong having a new statute. Gitu, do you have any sort of reaction to that question on construction adjudication?
Yes, I am a very enthusiastic supporter of this format of dealing with construction disputes. I have been involved in several before this new framework was developed, and I must say that this can only make the process better, more expeditious, less expensive, And to the industry, I think it's a great, great, great step forward. Construction arbitration in my part of the world has been very slow, very tedious, very prolonged, and the consequence of which is to escalate the costs of projects. This will make it cheaper, more efficient, and keep costs low. And I support it very strongly in our region.
Thanks so much, Ketu. Unfortunately, that's all the time we have for today. I'd like to thank all of our wonderful speakers for sharing their time and expertise with us today. We're very grateful for their contributions. Thank you as well to our audience. Thank you everyone for joining. For all updates and information on future Ciarb events, please visit our website and follow us on LinkedIn. And the recording of this webinar will be available to you later. Thank you very much again to everybody. Thanks for joining.
Thank you.
Thank you.